everyone. This is Christine Thompson, lead agent on the CT team. I wanted to first introduce you to my new co-lead agent, John Weslowski, that just joined our team, and Baird and Warner. John, introduce yourself.
Yeah, I'm John Weslowski, just joined up to partner with Christine and help her work with clients and hopefully get everything moving in the right direction here so we can start helping more people buy and sell properties.
And still offer awesome service, right?
Yes.
How many years have you been working, John?
30 years in real estate.
30 years. You beat me. It's more than me.
Yeah.
I'm 22, 21 years. Yes, I'm 21 years. So you beat me by 9 years. Oh,
right.
Gosh,
right.
Wow. All right. So we have Steve Shaykin here with us. Steve is an attorney that I regularly use for my clients because it's always very successful transactions. Steve, you want to introduce yourself for the people that have not watched our show before?
Good afternoon, everybody. My name is Steve Shaykin. I have a firm, Stephen M. Shaykin PC, out of Rolling Meadows, but don't let that location scare you. I go all over the place for closings. I'm often in Christine's office doing closings. So I've been a practicing attorney specializing in real estate for 40 years, and I think I've finally figured it out.
You got us to beat then. Right. So you got us to beat on years in the business. So, all right, we're gonna stick to one topic on the show, and I believe it's about wills and trusts. Is that right? Is that what you want to talk about, Steve?
I wanted to talk about a common problem that I encounter, and that is how people hold title to their properties and how they should hold title to avoid probate.
Okay.
Let me start by saying probate, it's not as horrible as everybody makes it out to be, but it is time consuming and expensive, and it is hard on the people that are left behind when somebody passes away. And there's simple things that can be done while someone is alive to set things up so that you don't have to go through that process. Probate is the process of taking the ownership of anything out of a deceased person's name and moving it to where it belongs. And where it belongs depends on either the laws of inheritance, if you have nothing, no will, no other type of arrangement, or if you do have a will, people think, well, I have a will, I'm covered. And you're covered in the sense that you've made the decision as to where you want your assets to go, but you have not avoided probate. And that's one big common misconception, is that, well, if I have a will, I don't have to go to probate. Yes, you do. You have to bring the will to the probate court, and the judge will then see to it that the will is followed. But they still have to go through the process of taking the ownership out of the deceased person's name.
Can I ask you a question?
Yes.
If you don't mind. So let's say they only have the will and it's got to go to probate. What's the typical time frame for that judge for it to go in front of the judge, for the judge to see the will and see, what the person wanted to happen, and to allow that stuff to happen in the will? What's the common time frame that you see? And what are the pitfalls within that process for the descendants?
That's a very good question, and it's a little bit more of a complicated answer. The entire probate process cannot be shorter than 6 months, and it typically runs about 10 to 12 months. If the heirs of someone were looking to sell a home or a property, they don't have to wait for the court process to be completed. They could sell the property right away, but the money has to then go into the probate estate, and it has to sit and wait until the process is complete and the judge allows everybody to get what they get.
Okay.
So
I got more questions about that, but I'm going to wait.
In one respect, there's no delay per se, but in the other respect, the finalization of it, there is a delay.
Getting the money is delayed.
Right. So people that are couples or more than one owner, they can hold title together in a form that allows for an automatic right of survivorship. And there's no probate involved. Most married couples hold their home in something called tenants by the entirety, which is 50-50 as an automatic right of survivorship. So if the husband passes, the wife owns the whole thing automatically. There's no probate, there's no nothing.
Is that
And
according
vice
to
versa.
Is that according to Illinois law or federal law?
That's Illinois law. And most states have very similar laws when it comes to things like that. Joint tenancy and tenancy by the entirety have been around. Tenancy by the entirety is only allowed for a married couple and only on the property they live in as their marital residence. So you can only have one property that is held as tenants by the entirety. You can have 15 of them in your life, but you can only have them one at a time.
Okay.
So a very similar form of ownership is called joint tenancy. That's an equal split and has a right of survivorship. It doesn't require you to be married to the co-owner. And tenancy by the entirety obviously can only have two people, because right now Illinois only allows two people to be married to each other at the same time.
We're not going to go
But,
down that road.
Right. But joint tenants can 3, 4, 10, and there's a right of survivorship amongst them all, and they have to be equal.
Steve, I have a
So,
question with regard to probate versus avoiding probate. Is there a tax liability involved with so you said you can sell the home, put the money into the probate account, essentially. Is there a tax difference depending on how you do it?
oh, another very good question and another somewhat complicated answer.
Mm.
Inheritance tax. Right now, federally, when you die, you have to have, and excuse me that I don't have the exact to the penny amount, but it's right around 14 million. You have to have an estate that is in excess of $14 million in order for any inheritance tax to kick in.
Oh,
So that alleviates the majority of people, but certainly not all. So, and inheritance taxes are steep. Now, Illinois has an inheritance tax, but their threshold is not as high. It's only 4 million. So that brings it down to certainly more of the population qualifies there. I kind of interpreted your question to be more about like income tax, capital gain type tax on the property. And we could do another whole conversation about that. But when a person dies, whether it goes through probate or doesn't go through probate, the people that end up getting the property, they acquire that property based on its value at the time of death. So if mom and dad have owned the house for 51 years and they paid $18,000 for it 51 years ago, and now it's worth $650. Mom passed away first, dad owns it all. Now dad passed away 2 months ago. So the 3 kids acquire the property, and they acquire it at the current value of $650.
I got a question. I got a question there. You said at time of death. So
Right.
let's say at time of death, a house is worth 500,000 and sits in probate for a year. And they say, we're going to wait until it's out of probate to sell it. And now it's worth $600,000 because we've had crazy increases. Is it at the 500,000 value or the 600,000 value when it sells?
The basis, the income tax basis is 5. That was the value at the time of death. And then the expenses of the sale lower that because you've got commissions, real estate tax credits, other fees and expenses, and maybe some expenses along the way while you've owned that property for a year. Those come off as well, but there's still probably going to be a gain left over on in that situation. But most of the time, if they sell it and it's not the, we are in a little bit of an interesting market for sure. But if they sell it reasonably quickly, there might be even a little bit of gain, but it gets eaten up by the expenses. So
Yeah.
ultimately
yeah.
there is no gain and therefore no tax.
All right.
But a big mistake that people made, and that's not what the intended conversation was, is that people think foolishly that, well, when I die, I don't want the government to come and take my property, so I better give it to my kids or whatever now while I'm alive. That is hugely wrong, because when you give it to your kids while you're alive, the kids now acquire it based on what mom or dad paid for it. They don't get the value as of date of death. They get the value as of when mom bought it. And then when they go to sell it, Uncle Sam is sitting there with a smile going, oh, you guys paid $18,000 for it and you just sold it for $650. So that's at least $550,000 worth of capital gain. Thank you very much. Pay us.
So
That-
even
that
so, like if the parents say, we'll just pass the deed and title over to our kids before we die, they're gonna look at
Bad
it
move.
like bad move.
Bad.
Good point
Huge.
to bring up, Steve.
Hugely bad.
Steve, the reason that it's bad is because had the parent kept the home in his name until he passed away, and it was transferred through inheritance.
Through any type of acquisition upon death, the kids would have acquired it at value as of date of death. And all that gain
There's
over
no
all
gain.
those years is wiped out.
Wow.
Right, interesting.
Good to know. Yeah.
So to quickly into ways to avoid probate, the simplest way is to put your property into a trust. There's a simple trust that is referred to generically as an Illinois land trust. And then there is a little more complicated trust called a living trust. And the living trust is just like a will. It does exactly the same things that wills do, but it's done through the trust vehicle so that probate is avoided. And the concept is easy. When you put a property into a trust, the technical legal owner of the property is the trust. You may be the beneficiary of the trust and you have all the benefits of being an owner. If you own a home and you put it into a trust, your world isn't going to change one bit. You're not going to know the difference between owning it in the trust or owning it directly in your name from a practical standpoint. But from a legal standpoint, you don't own the property. The trust does. And when you pass away, the technical legal owner of the property has not died because that's the trust. Trust didn't die, just the person died. And the trust self-perpetuates to say, well, if this beneficiary dies, now these people step in and they're the beneficiaries.
Right. And in
So
the trust
is still the trust. So at the beginning, I said probate is the legal process of taking ownership out of a deceased person and moving it where it goes. When it's in trust, the person doesn't own it technically. Therefore, there's no probate needed. You don't have to take title out of a deceased person's name. Title was in the trust before they died. Title's in the trust after they died. And it's just who reaps the benefit of the trust has changed.
Right.
But the income tax benefit, John, is the same either way. Whether you inherit it and go through the probate route or you acquire it through the trust. And the nice thing about the trust is it goes beyond just mom and dad. Okay. So because you can still do joint tenancy by the entirety, but then it can be upon the survivor passing, it goes to my kids or it goes to some of my kids or it goes wherever. And especially if you have young kids that are not yet 18, you don't want them to inherit a a third of a property worth $1 million when they're 10 years old, because that creates additional problems that I'm not going to have time to explain, but it does. So by doing it through a trust, that property can stay in trust with the whoever is the new trustee monitoring and doing what is necessary. And it can be then per the trust agreement, when does this child get their 1/3? Do they get it when they're 18? Do they get it when they're 22? Do they get it only if they go to college, or do they have to wait longer if they don't go to college? Motivation from a parent to, who isn't going to be there to be a parent for those kids at that time.
How many layers can there be beneficiaries? Like say the husband and wife die, goes to their sister because they know this in case of children, whatever, goes to a sister. And then if the sister's not available to receive the trust, it goes to the daughter, and then it goes to a niece, and then it goes to a nephew. Like, how many times can it be passed off to somebody else?
You can have as many layers as you can have as many layers as you want, as creative as you.
So is it something like, could it pass around for like 100 years through generations, or the names have to be existing in the trust? They can't revise a trust and say, hey, a new generation has been born, we're going to have them as the last beneficiary.
Well, keep in mind, you can have all these layers, but once it hits a layer where there's someone to acquire it, that's where it stops. So the layers are, upon my death, it goes here. If this person isn't alive, then it goes here.
Oh,
and if that person isn't alive, then it goes here. And if that person isn't alive, then it goes here. And you can endlessly do that. But eventually you're going to hit someone who is alive.
And that's when the trust ends?
That's who gets it. And then it's theirs. And then they can set up their own trust at that point, and they can keep it going. And it's interesting that you brought up the topic of leaving it to people who aren't in existence yet, because we spent like 2 months in law school learning about something called the rule against perpetuities, and don't bring me back to that, because it's
okay. I didn't know if there was something where it could just keep extending, because I'm thinking like the Vanderbilts and their big mansion.
A trust can live on. A trust can live on for generations to generations to generations.
Okay.
It can, because it's not
revise it and update it.
It's not a biological entity. It's a legal entity, and it can live in legal existence longer than people, and just new people keep popping in to control it and to reap the benefits of it.
Yeah. I would love to look to see what the trust is for that, the Biltmore in North Carolina. Largest house in America.
I was there. I did the tour.
Yeah. The largest house in America. What is it? 127,000 square feet, something like that.
Wow.
It's almost
for the time frame that it was built in. Some of the things it had were quite amazing.
Oh yeah. Yeah. Have a refrigerator in there in the 1800s.
It had a built-in pool.
Yeah, I know. It drains though. They can't run it anymore. They had a party one time and they filled it for a big party, and then the next morning the pool was empty. Oh. They woke up and they're like, where's the water?
Oh boy.
Anyways, I don't know. I just thought of that. Like, they still own all that property. And I'm like, do they have a perpetual trust that is keeping it in the city,
that property was like 20 or 30 times bigger at one point than it is now. They've sold off.
They sold off a lot of land, but I think originally
it's already ridiculously large. But it was like 1/3 of the state,
I know.
The bottom
it's probably bigger than Naperville. They said they had a 195-mile span of land ownership.
Wow, that's crazy.
That's all. I wouldn't want to mow that.
Steve, one quick question. You can keep it a real short answer, but just so I understand, what's the difference between a living trust and a standard trust? Why would I put something in a living trust versus a standard trust?
Well, an Illinois land trust, which is what I'm going to jump to, your standard trust, is it can only hold real estate.
Oh,
And a living trust can hold anything.
like
It can hold,
cars, jewelry,
it can hold
artwork, and
stocks, bonds,
bank accounts.
bank account, life insurance policies can name the living trust as a beneficiary.
Oh.
And so
More
then
than just a house.
everything would flow through and, and just a house.
All right, so I
Now,
got,
land trusts are very useful, especially if you own multiple properties as investors. Rather than keep them all in your name, all your eggs are in one basket, you separate them into each separate land trust. Now, and land trusts aren't that expensive. I mean, they're not free, but they're not that expensive.
right.
And
compared to
you
living-
now have each entity is separated. So if you run into a problem on property A, that problem doesn't spill over onto property B, C, and D. It is self-contained within property A. And I have lots of investor clients and they still say, well, I'm just going to put it in my name. Well, then you've got, if something happens to that person, now you've got
big legal
a whole
problems.
bunch of properties that are either going through probate or something
Yeah.
that, has to be addressed. So
If you're an investor out there, get a land trust per property that you have. So that way, if you get any kind of lawsuit with a tenant or something, they can only go against after the value of just that one house, or can they even go after that if it's in a land trust? Because it's
exactly. Well, they can, but it's a little bit, there's a layer of protection, but they can eventually get to it. A lot of people use LLCs. They put every property into a different LLC, and there's a thing called a series LLC. But what the LLCs don't do is they don't do anything having to do with the succession of ownership upon death.
right.
So the land trust not only separates it, but in your land trust, you can then say, upon my death, this property goes here, goes, A, B, and C. And
I got a question. Could you have like all the land trusts and then all the land trusts are in the one living trust?
Yeah, you could do that too. But yes, you could have the beneficiary of each land trust be the living trust.
Okay.
And
one last question, because we got to get going. And I'm sorry to cut you short. People can jump in and ask questions later. I'll get them hooked up with you. Okay. But I got one last question. Well, let's say something's sitting in probate for 6, 10, 12 months. Is it something where they have to put out publicly saying this is in probate? And then we get all these people going, oh, I'm going to pretend that they owed me $5,000 for a painting job. Or a plumber can go in there and make a claim. So can that happen while it's sitting there in probate? And all these people are going and leeching money off of it, claiming
Christine, you are so insightful with your questions about
this. It's the German in me.
The most negative part of probate is the fact that it's a public record and that as part of the process, you have to publish that this probate estate is open, that Christine or whoever has passed away and there's this probate estate. And if you think Christine owed you money, you've got 6 months to come in and file your claim. And so that's probably the biggest reason of all to avoid probate.
Right, because the person's dead. They can't argue, no, I never hired that to paint my house. So people are just going in there, submitting their claims at court or wherever, saying, hey, yeah, they owe me. I want to collect now. So somebody could go in there and say, they owe me $50,000 for some jobs I did in the house.
I'll give you a more, not that that's unrealistic, but something that happens all the time is credit cards. Credit card companies read the obituaries all the time. And then if they their computers do it. And if a name matches up with one of their account holders, they look to see if there's a probate estate because they can put their claim in. Oh, well, they had a credit card balance with us. And that lessens the amount that the heirs of the estate are able to acquire because those things have to get paid. Also, what gets claimed in probate estates often is medical bills, because when people die, they usually don't just walk down the street and then die. They usually are sick and incur medical bills, and sometimes more than the insurance is able to cover or is required to cover. And then the medical providers can file claims for their bills. So all of these are good reasons to stay out of probate.
Yeah,
And that
that's what I
is
heard.
our conversation of the day.
Yeah, and it was very good. And I'm sure there's a lot more that you can talk about, but you're going to provide your contact information. So if somebody wants to talk to you more about probates and trust and wills and all that stuff, they should just call you directly, because it's a long conversation to have, and we don't want to. We got to go.
The
We got to
best-
get going. You got work
The
to do.
best number to reach me is my cell. It's 224-595-1216. And my email is pretty simple. It's my name, Steve, not Steven, just Steve, at shaykin.com, SHAYKIN.com.
Awesome.
So either way, I'm happy to engage in conversation about it and hopefully help people out.
I appreciate it, Steve. If you're listening and you need to talk to John or me, you can use the same phone number. You can text 2 different codes, either to get John or me. Text the number 630-931-0045. If you want to get in touch with John, just text Let's Chat JW. And if you want to get in touch with me, text the code Let's Chat CT. Thank you for watching the show. If you really enjoy this, we plan on doing this every week, either with Steve or with my lender. I might try to bring an accountant into this one, because there's some questions that come up that, Steve, you probably don't feel like you should be talking about when it comes to accounting stuff that's sort of interrelated with what you do. But we try.
I'm not an accountant.
Yeah,
don't
you're
even
not.
play one on TV.
I don't want to put you to that. So just subscribe to my YouTube channel, Living in Naperville, even though we cover more than Naperville. And we will be posting these shows once a week. We try to keep them super informative. And then that way, you know who to contact if you have further questions. Thanks for watching, Steve. We'll see you in a couple of weeks. And I appreciate y'all watching, and subscribe to the YouTube channel, Living in Naperville with Christine Thompson. Take care.
Welcome to the team, John.
Thank
Looking
you.
forward
Yeah, thanks,
to
John.
working with you.
Yeah, good to meet you.
Bye.